Hey, good morning, everybody, and thank you very much for taking the time to join us this morning in what is our final social housing webinar of 2022. And this morning's webinar is 10 points to consider when looking to develop a new site for housing. Just to introduce myself, for those of you that I haven't met before, my name is Fiona McLeod. I'm a Senior Associate and Solicitor Advocate within the Government and Regulation Competition team in Brodie's, with an accredited specialism in housing and residential tenancy law. I'm not going to be doing very much of the speaking today. I'm simply hosting, and I'm joined today by our speaker, Charles Hay, who is a Managing Associate within our real estate team. So Charles, I will simply pass over to you, and I will see you all at the end for a Q&A session.
Thank you, Fiona. Hoping you can all hear me all right. So yes, just as Fiona mentioned, I am Managing Associate in our Glasgow real estate team. I have done a number of developments for clients, which includes housing developments, some mixed-use developments, acting for residential house builders, some registered social landlords, and as I say, for some commercial clients with regard to some mixed-use developments as well. So thank you for taking the time to join us for this presentation as part of our social housing webinar series this morning. My presentation today is to look at a 10-point checklist for residential development. As I said, it could actually be a development for mixed use as well. A lot of the points obviously apply to both a residential type development or a mixed use development. But I thought it would be a benefit to consider it in the form of a checklist that raises the kind of pertinent questions that should be covered off as early as possible as part of any development project. It may be questions that you would want to ask of your client if you're instructed on behalf of the developer with regard to the development, or if it is the case that a site is being procured for housing for you, then it's the sort of questions you might want to raise with the developer and their professional advisors at an early stage, at a stage where the challenge that can arise from the points I'm going to refer to can be dealt with. And there's time to deal with, rather than at a last minute where there may not be the time to deal with some of these nasty issues that can arise. So if I can move on to the next slide. This is my kind of 10-point checklist. So these are the 10 points I'm looking to just try and briefly make comment upon. The first one is site assembly. So obviously looking at what's involved in just looking at the extent of the property that you're needing for the purposes of procuring the development and the issues that can arise as a result of assembling the site. It may be that your development is proceeding on a single title, a single registered title, hopefully, and that would make things a lot easier. But in many cases, we could be looking at assembling a host of titles that partly registered, partly seizing, and just the points maybe to bear in mind in that type of scenario. Then looking at some of the title conditions. So number 2, minerals reservation. If there's a reservation of minerals with any part of the title, what would you be looking for? What could you do to try and address potential issues arising from that? Again, just title restrictions generally, looking at possible preemption rights within the title, or restrictions so far as obstructing development on any part of the site. Again, how can you address these challenges? Number 4, third-party rights, which again looks back to restrictions on the site. Is there any third-party rights which would cause a problem as far as building out as per your proposed layout? Number 5, access. Crucially, do you have all the rights of access you need to get to the site? Now, that's not only just in terms of pedestrian vehicular access, but also for bringing services into the site. Off-site infrastructure. Is there a requirement for there to be infrastructure located out with your development site? What do you need to do? What do you need to bear in mind when looking to put that in place? Number 7, planning conditions. So if you've got your planning consent and your list of conditions, again, what are the points that need to be borne in mind? Number 8 is tax, so VAT, just specifically just looking at VAT in relation to site and just briefly covering up a couple of points as far as that's concerned. Number 9, if the development is a larger site, you might be looking at a phased development. What's the sort of things that you would want to be ensured in place at the outset as far as proceeding with a phased development? And lastly, there may be some ancillary documents that are required for the purposes of the development. And again, just giving a couple of examples as far as that's concerned. So if we can move on to the next slide, which is looking at the aspect of site assembly. So this is pulling together the titles to the area that you're looking to build out. What do you need to acquire in order to ensure that you've got the ability to develop what is your, and in this case, as you'll see, it is a proposed layout. And that's really the first point of reference that I would be looking for in this respect. And that's a plan from the client showing what is the proposed layout for the development. And you'd expect this to be part of the planning application. Obviously, that's what the clients are looking to get consent to build out. So how do we fit that within what property there is to acquire? I would look to take that proposed layout plan and overlay it against the cadastral map as maintained by the Registers of Scotland. Obviously, we have access to the cadastral map through the ScotList facility on the Registers of Scotland website. So we overlay that against the cadastral map. We can identify those areas within the within the development, which are registered titles. And through the ScotList system, again, we can pull off copies of the title sheets, identify proprietors, and that also gives us a view as far as the title restrictions are concerned. I would still be looking to get a plans report, even if all of the subjects that are required for the purposes of the development are registered titles. I would still be looking to get a plans report from the Registers of Scotland. I've looked for a level 3 plans report. As you'll appreciate, a level 3 plans report would confirm, first of all, if the plan that's been submitted for checking is suitable for registration, it meets the Keeper's Deed Plan criteria. It provides a list of the cadastral units which are conflict with the subjects of the report. So it gives you a list of what are the registered titles that lie underneath your overlay. So we can just check again that we're getting the full extent of the title that we require. It also gives us a list of cadastral units which provide non-conflicting with relevant non-conflicting information from the cadastral map. So these are titles which are creating perhaps rights of access or impose burdens on the area that we are looking to acquire for the purposes of the development. Again, as you'll see when we come on to some of the other topics in the checklist, it's important for us to establish as to what third-party rights there are in respect to the site and what title restrictions. So this is giving us an access to the title information, again, that we need to check in that respect. It will also advise as to whether the subject's extent corresponds with the relevant features as defined on the current version of the OS map. So it will show up if there's any discrepancies between what is shown on the plan and what is shown on the OS map in terms of physical features. And lastly, it also discloses any registered shared areas which affect the subjects. And clearly, if there are shared areas affecting the subjects, then that can cause, well, it flags up an issue right at the outset in terms of the ability to acquire the necessary exclusive rights if there are areas which are shared areas. Now, this plan that is on the screen just now is a layout plan for a development that a client of mine was doing in Johnston. And if we move on to the next slide, you will see that this is a plan showing the underlying titles here. Now, this was a plan that was prepared by Land Ownership Scotland at our request, because we knew that the site here, having done an initial overlay, included areas that were not registered and areas that were registered. So the areas to the south, the areas delineated blue, and I think it's perhaps red, my colours might be a bit mixed up there, were land registered titles. So we pulled off the copy title sheets as far as those titles were concerned. But the areas which are shaded, so the areas that are shaded blue, pink, and I think that's red, and some other areas that are marked on that, were all Saysian titles. And we had instructed Land Ownership to provide us with a title report in respect to these areas to establish details of who the current proprietors in respect to these areas were, details of the writs referred to for description, so that we could establish the exact extent of these areas and whether that all corresponded with what Land Ownership were showing on the plan. An added complication with regard to this site is that certainly I think the areas shaded blue in this were previously built out as tenement properties and had since been demolished. So not only did we have issues in terms of establishing that we had the extent of the property correct per what was on the ground, we also needed to make sure that we acquired all the rights of the former proprietors of the flats. So obviously those then are the airspaces above the ground, which had previously been occupied by flats. So there was quite a bit of assembly to be done so far as this is concerned. In this case, we were acting for the purchaser, although our client as a developer was then looking to do a deal with a registered social landlords for affordable housing. So we had a scenario whereby we were checking the sellers, that the seller had acquired all the necessary rights to do the development as per the proposed layout, but we also needed to ensure that the advisors for the RSL were comfortable that we had acquired proper title with a view to transferring that title on to them. So we needed to basically get ourselves comfortable that a conveyance by the seller of the various areas in this was within the ability of the seller. So basically that the seller's title included the full extent of the areas shown on this plan, because obviously we're then making the application to the registers for registration of our client's title, and we've got our duties in terms of the Land Registration Scotland Act 2012 to show that we've taken reasonable steps to ensure that we are not inadvertently making the keeper make the land register inaccurate as a result of not having a proper title acquired from the sellers in this respect. One way which we used to deal with these sort of matters was by using the plans assistance service that the registers maintained, whereby you could ask the registers to prepare a plan of the area for annexation to the conveyance, and then you felt reasonably comfortable that the registers would then be comfortable so far as taking that application on the register. Unfortunately, that was one of the services which was temporarily suspended when the COVID restrictions came in and has not been reintroduced. Now it didn't really provide a different service than something which Land Ownership or Miller and Bryce can provide, but when you have something that has the register's stamp on it, then that always tends to give you a greater degree of confidence so far as that the subjects reflect a true representation of what is the seller's title. But looking at the various deeds which we had to review from the Saysian copies, we were struggling in some respects because some of the deeds did not have plans attached to them, and that meant there was also an element of establishing what were the physical features on the ground, so that those tied in with what we were mapping out on the plan. So for example, again, this area to the northwest was bounding onto the back gardens of other established residential properties. So again, there was views taken that the boundaries with what we were looking to acquire from the sellers, if there wasn't a plan as part of that area, which is shown shaded red on the plan, that it was taking us up to the boundaries of these other physical features. So there's an element in terms of not only just looking at what is the information being provided by way of the copy deeds, but what also is the position on the ground. If we can move on to the next slide, and moving on to the next point as far as the checklist, and this is the issue of minerals. So this is starting to look at the underlying titles and what is the title conditions and restrictions that are included within the underlying titles. And the first one to look at again is just what is the position so far as the minerals are concerned. Now, as you'll be aware, minerals constitute a separate registrable interest so far as property in Scotland is concerned. There are many instances of titles in Scotland where the minerals underneath the property are reserved to a third party. If you are looking at developing a site where the minerals are reserved to a third party, then there are some potential risks which should be covered off. The most immediate risk is whether your proposed development is going to disrupt or obstruct access to the minerals and thereby create a situation whereby the owner of the minerals may seek to enforce their own rights with regard to the minerals. There's no exact science here as to whether a development would naturally disrupt the minerals beneath, and it does depend as to obviously what works are going to be required as part of the development, what are the minerals underneath the site, and what are the actual minerals that have been reserved to the third party. If you have a development which is going to involve some infill and grouting, then the chances are that it will affect the minerals beneath. But you also need to check, as I say, what are the actual minerals that are reserved to the third party. Some titles just have a catch-all provision so far as all minerals are reserved to the third party of whatever nature. Now, as you may well be aware, coal is reserved by statute to the Coal Authority, but that's not really usually the issue for us. The issue more in terms is what is the minerals that are nearer the surface that would be the ones that most immediately affected by any development. There are some titles which, whilst there's a reservation of the minerals, they exclude from that reservation the sand, clay and freestone, and there may be other ones that they refer to from that reservation. So those are not owned by the third party and would go with the title to the developer or to go with the owner of the site. If the owner of the minerals can establish that the development will disrupt their property, then they could seek to enforce their rights by way of an interdict to prevent development until a satisfactory position is reached with them so far as the impact upon their property. Now, a caveat for your client in order to protect against interim interdict still only gets you to the problem of trying to resolve the aspect of the minerals. And we do know that in some areas of Scotland, the owners of some of the minerals are more active than others. So what's your other options so far as that's concerned? Well, of course, the first instance is you could approach the owner of the minerals and look to either acquire the minerals underneath or seek a waiver of their rights to prevent development. Of course, if you do that, then you're immediately flagging up to the owner of the minerals that there is a potential issue there, and you're going to need to then seek to get some sort of agreement. And obviously, if you can't reach agreement, then you put yourself in a difficult position as far as progressing the development. A more common way of looking at it is to get title insurance, but that is only just trying to cover off the risk of any potential challenge coming your way from the owner of the minerals. And say the insurers will look at each case on an individual basis to see as to how active the owner of the minerals is with regard to enforcing their rights in respect to that area. They will also look at the reservation and see what is the actual terms of the reservation, and again, to what extent they would be willing to cover that risk. Even if you're not concerned about any obstruction to the development, if the minerals reservation does not include adequate rights of compensation so far as any damage to property on the surface as a result of previous or future workings of the minerals, you might still look at title insurance more as to cover off the risk of damage to the development, or as a safeguard so far as future purchasers, future plot purchasers, and basically again to address the issue which will sometimes arise at the point of doing the plot sales in terms of what kind of comfort are you providing to plot purchasers where there is basically inadequate compensation provisions within the minerals reservation. Of course, other things to consider again is just how likely any minerals development would be, how likely would the owner of the minerals get permission to do any sort of development. This is all relevant so far as I say, that stage of looking at the future disposals. If we can move on to the next slide. And again, just coming back to the issue of restrictions on the title that might impact on development. But the first issue, again, if there is within any of the deeds for the property burdens that would cause an issue so far as development, is there title to enforce these, or who has the title to enforce that title restriction? And crucially, do they have interest to enforce? So obviously, so far as title to enforce, you're looking to identify within the titles as to who is the benefited proprietor with title to enforce the title condition. Also crucially, would a breach of that title condition materially impact upon the value and amenity of their benefited property? As you know, they have to prove both in order to enforce the restriction, but again, there's always this aspect of, do you take a risk if there is a title condition there that would restrict development in going forward with development, and then finding they're able to establish title and interest, and you've got a problem. Now, one of the more obvious title restrictions that need to be dealt with as part of any development, purchase for a development, would be if there is a preemption right within the titles. If there is a preemption right within the titles, then you're looking for evidence that this, if it should have been dealt with at an earlier stage and an earlier disposal, that it was properly dealt with, and that there's a record that the party with the right to the preemption was given the option to purchase as per the terms of the preemption and did not take it up. It is important to keep that information as part of the title in order to be able to show that the preemption right has been extinguished, as is the provision in terms of the 2003 Act, as a result of it having been properly dealt with at that time. If there's no evidence that it's been properly dealt with, then you probably have to deal with it now as part of your deal. And again, you would want to make sure that this is dealt with using the relevant provisions within the 2003 Act before you spend any more money on a development site that potentially you might not be able to proceed with the purchase of. As I say, in terms of the 2003 Act, if there's evidence that it's been properly dealt with, then it is extinguished. In terms of other title restrictions and how you might look to extinguish those or get round them, well, if we look at, first of all, the basis upon which you can seek an extinction of title conditions, these are set out again in terms of the Title Conditions Scotland Act 2003 and sections 15 to, I think it's to about 24. The first one being a straightforward discharge in terms of section 15. Now, obviously, for the purposes of getting a proper discharge of a title restriction, a burden, then you require to identify who the benefited owner is. Now, if we're talking about community burdens, then that clearly is going to be a lot more difficult, depending on obviously the number of parties who are deemed to be burden benefited proprietors for the purposes of those burdens. But if we've got a clear title restriction that is for the benefit of one or two other parties, then a section 15 discharge is the preferred option. That is the most clear way in terms of completely removing the issue going forward with the development. Section 16 provides extinction by acquiescence. Now, for this to operate, the real burden must be breached in such a way that material expenditure is incurred, such as, going ahead with a development on a site where there is a no-build title restriction, and any benefit arising from such expenditure would be substantially lost were the burden to be enforced, and the benefited proprietors consent to such breach, so do not object to the housing development going on, or at least ought to be aware of the fact that this is ongoing and have not objected within a period of at most 12 weeks. So this depends upon you showing that the parties entitled to object are consenting to this breach or should be aware of the breach and have not taken any action to object. Now, again, you run the risk of you actually have to incur that expenditure in order to show that you are triggering this acquiescence provision. Also, in terms of section 16, the burden is extinguished to the extent by which it is breached. So again, different obviously from section 15, where you can get a straightforward discharge of the actual title condition. You're not extinguishing the title condition, you're only extinguishing it to the extent of the breach. In terms of section 17, if you can show that no one has interest to enforce the title condition and you breach the title restriction, then again, it is extinguished to the extent of the breach. So that requires you to show that first, there is a benefited proprietor with title to enforce, they don't have interest to enforce, which again, as I say, is probably the most straightforward ones, whereby you can get an express grant or express consent to the by the benefited proprietor, gives you more confidence. This one, as I say, is dependent on showing that no one has interest to enforce. Section 18 provides for extinction of real burdens by way of negative prescription. So if the title restriction is breached and a period of 5 years elapse and there's no claim or acknowledgement by the benefited proprietor objecting to the breach, then it would be again extinguished. But again, that is dependent on how it is breached. It's extinguished to the extent of the breach. Section 20 is what is commonly known as the sunset rule, and provides a way to deal with some of the more historic title conditions. So if the deed that gives rise to the title restriction was registered over 100 years ago, then the developer can seek to extinguish it by virtue of intimating to the beneficiary proprietors and intimating on the site that they intend to register a notice of termination at the registers. And in terms of the notice which they are prescribed to give to all the interested parties, they will advise them of the time limit, which has to be at least 8 weeks, whereby they can, or within which they have to submit an objection notice to the Lands Tribunal. Assuming that there is no objection, then the Lands Tribunal would provide a certificate to say that there has been no objection received, and that then the notice can then be registered at the registers in order to extinguish the relevant title condition. Obviously, if there is an objection submitted, then the process has to can't proceed in that respect, and you have to then look at alternative options. And of course, the alternative option may be to apply to the Lands Tribunal for a discharge of the title condition. You can also seek to get a variation of the title condition, not necessarily a discharge, by application to the Lands Tribunal, and that is obviously by the burdened proprietor. And the various factors which the Lands Tribunal will then consider that application are set out in section 100 of the Title Conditions Scotland Act 2003, and there's quite a few, I can't remember the exact numbers, about 13 factors or so, which the tribunal will go through. And if you look at the decisions on the Lands Tribunal website, so far as variation of title conditions, you can see how methodical the tribunal will go through these various heads in terms of looking at, well, what is the prejudice to the benefited proprietor if the application is granted? To what extent is it basically an unreasonable burden on the burdened proprietor? To what extent circumstances have changed? Is there other forms of compensation available? As I say, a methodical process to go through to establish as to whether, in the opinion of the Lands Tribunal, that title condition should be discharged or varied. Going on to another form of restriction, if we go on to the next slide. This is to do with third-party rights that affect the site. So these are rights which a third party has in respect of the site that you're looking to acquire, which again can potentially cause an issue, an obstruction with regard to your proposed development. Now, these can take the form of those which are kind of ex facie valid, and there's those which can take the form of implied and unseen. So obviously the ones that are easier to deal with are those that are visible from the title deeds. For example, if it's been a deed of servitude granted in favour of a third party that is restricting or affecting part of the site. The issue is obviously whether you can design that into your layout, or if you're looking to potentially vary the routes of that servitude, then again, an application to the Lands Tribunal under section 100 for a variation of the servitude can work. It may be that there's reserved rights in terms of the grant of the title in favour of the seller of the site, and again, just to see as to what extent those rights can be varied, and the factors within section 100 again are relevant. There may be a lease registered against the title in that respect. These are sort of things also which, just talking previously about the plans report in respect of registered subjects, can be thrown up as part of the planned report, and then you're looking at issues so far as the seller procuring a surrender of that lease, if that is what appropriate. Now, there may be leases affecting the site which are not registrable because they are not in excess of a 20-year term, and you're dependent on the seller giving you the information in that respect, or it may be again apparent from what is on the site. So, for example, if you're looking at acquiring a building and it is occupied, then these are sort of things which should be apparent so far as what is the basis on which that occupation is being taken. Obviously, as part of the sale contract and the conveyance, there will be the warranty provided by the seller. But again, it's so important just to get as much information at the outset to identify what are the issues that will need to be dealt with. Looking at those that are not maybe apparent from the title deeds. First of all, those rights that are implied, and I've referred here to a servitude right established by necessity. Now, this is a servitude right which is created not by way of express grant or prescriptive use. It is established by virtue of the fact that there is no other way, for example, to access a site if the site is entirely landlocked. So, for example, if you're looking at a development site that potentially surrounds a property, or certainly creates a barrier between a third-party land and, say, for example, public access, then there may be, by implication, a servitude right of necessity granted in favour of that third party. Now, with something like that, again, given that it is a servitude right by necessity, you may be able to vary the route of that and deal with that as part of the development. But again, it's just establishing, first off, if that is the position. There was a recent case, Salisbury versus Jones, which looked at the issue of servitude right of necessity. Now, in this case, the proprietor of a property was arguing that they had a servitude right of necessity for the purposes of accessing the exterior of their property in order to carry out repairs. That access was going to be blocked off by their neighbour carrying out an extension to their property. But the view in terms of that is a right over neighbour's property in order to access your own property for repairs, etc., is not what you would be looking to include within that category of a servitude by necessity. It's a more kind of infrequent right, this idea of carrying out repairs, rather than, for example, if the property you own is entirely landlocked and the only way to and from the property is over the neighbouring land, then that is more where the servitude right is established by necessity. But it gives a good narrative so far as what are the conditions that are required in order for a servitude right to be established by this implied right of necessity. The next category, servitudes which are created by way of prescriptive use. So that is where it can be shown by third party that they have exercised a right of access openly, peaceably, and without judicial interruption for a continuous period in excess of 20 years. Again, you're looking to see if there's any evidence on the ground so far as whether this could potentially affect the site that you're purchasing. For example, given obviously that there may be areas previously used for storage or parking, does that create a servitude right in favour of a third party? Obviously, there's the servitude right of parking, which was fairly recently established again, that somebody could be seeking to claim if there's an area which has been traditionally used for parking vehicles, such like. Of course, that requires the party seeking to claim the servitude to establish that there has been this right created by way of the in the process, rather than just by way of any express grant. It may be that the rights are created by way of a statute, such as telephone mast operators have rights under the Telecommunications Code, even though their rights, perhaps by way of a telephone mast lease, have been extinguished. It may be that you're looking at a public right-of-way, and again, this should be apparent from the physical evidence on the ground. If there's a clear route, a clear defined route, which is regularly undertaken by members of the public. Normally a report from Scotways, who maintain the Register of Public Rights of Way in Scotland, is your first port of call in this respect. Moving on to the next slide. Access. So in terms of accessing your site, can you access the site to the nearest publicly adopted road? Your first port of call in this respect would be looking to see what is shown on the list of adopted roads maintained by the local authority. Although a recent case, Leaf Realm Limited versus City of Edinburgh Council, indicated that the list cannot be depended upon as being the determinative factor so far as the extent of an adopted road. You do need to look at what is the actual functionality of the area over which you're looking to claim access. So, for example, does the site lie adjacent to an area formed as a road, formed as a verge, so part of the road itself, or a footpath? Obviously, your best position here would be to get a plan from the local authority with relevant shading showing the extent of the adopted road, and that would give you the sort of greatest degree of comfort. But again, you're looking to see as to whether in fact the location of the adopted road and where you'd be looking to take access fits in with your current layout. Just because the site lies adjacent to an adopted road doesn't necessarily mean that that is where you're looking to take access. Also, for the purposes of looking at the extent of the adopted road, is that where you'd be looking to bring your services into the site? And that again would give you the ability to put the services and for the utility providers to access their relevant services. One point just to bear in mind in terms of this, and this is this idea of the bridge, and if I can just move on to the next slide, I'll just see what I mean in this respect. In a case, Irvine Knitters Limited versus North Ayrshire Co-op, the point here was that there was a property which had been acquired for development, which in this case will show as property number 1. It was a benefited property for the purposes of a servitude right coming off the road. The developer also owned a second property which was immediately adjacent, but they were held on separate titles, and he was looking for that servitude right that was benefiting site number 1 to provide the access similarly for site number 2. But of course, because of the general rule that if you are a burdened proprietor, you're entitled to ensure that the servitude does not impose any greater obligation or any greater burden on you than the terms of the servitude granted. And in this case, the idea that the access would be used for the purposes of benefiting site 2 as well would be an increase on that burden, and therefore they were entitled to insist that the servitude was only there for the benefit of site number 1. And this again was recently reaffirmed in a case of called Ruddiman versus Hawthorne. And in that respect, the court again upheld the fact that just because you own a couple of properties which are adjoining each other, that does not give you the right to use the benefit of that servitude for both properties if only one of the properties is identified as the servient tenement for the purposes of that servitude. Again, it's a case worth looking at if you're looking at services access to a site which is made up of a number of different titles. Moving on to the next slide, off-site infrastructure. If you have infrastructure which requires to be located off-site, such as a substation, or if you're looking at a surface water drainage going into, for example, the adjoining field or such like, then you may require to obtain rights over that third-party land, which of course will necessitate the grant of a servitude, negotiation of that servitude with the neighbouring landowner. If you are ultimately looking at that infrastructure being adopted by utility provider, then you need to be aware of the utility provider's preferred styles, and they would normally look to have the servitude in their favour so that they've got the access to maintain their equipment and such like, and also potentially looking at using that infrastructure for other developments such like. Just to quickly rattle through, because I'm conscious I'm probably at the end of my time. So if we could just go on to the next slide on that one, planning conditions. The point we're really just looking to make here is once you've got your planning consent, it is obviously important for you to review the planning conditions to establish as to whether there are any additional rights that you're going to require. Now, these things probably would come to light during the negotiation so far as the planning conditions are concerned. For example, if you are needing to install some road infrastructure, such as a roundabout or widening the road access, then again, you may well need to get additional rights from whoever owns the surface of the road, or the immediately adjoining areas, such as I say, also for widening access or maintaining a visibility splay. There may be a requirement to carry out work on third-party land, and in that respect, you may be looking to negotiate a license arrangement with a third-party landowner. So I think the point really just with regard to this one is just to ensure that as soon as you're aware of the planning conditions, just to review those in the context of what rights you have and what you may require. Just on to the next slide, VAT. If there's an election by the landowner for the purposes of waiving exemption from VAT, then VAT will require to be charged on the price which you're paying. There are exceptions to that, which you're probably aware. The most important one being that if it is a sale to a housing association, an RSL, then they have the right to serve a notice on the seller to disapply that notice. But the important thing is that has to be done before the supply is made, and in our case, that should be before we conclude a missive, because clearly the VAT needs to be addressed within the contractual provision and can go to the heart of the commercials. Obviously, if you are looking at a VAT issue, you may be looking at trying to do a sort of golden brick scheme whereby the property is being sold to the RSL or the developer who's doing it for the purposes of an affordable scheme will want to ensure that the VAT is zero rated, so that it is sold as a residential development site, and that would involve some work being done on the site to bring it up to that golden brick status before they actually complete the sale of the site. Just go on to the next slide. Phase development. If you're looking at potential development being done in phases, then the advice there would be just to make sure that you've got an overarching deed of conditions over the whole of the site that comprises the various phases in the first instance, to ensure that there are reciprocal rights to access and connect into the infrastructure that will go in to service the various phases, as that will ensure then that as the phases are sold off, they each get the benefit of these rights to connect into the infrastructure that spreads across the whole site. And lastly, If we go on to the next slide, a couple of ancillary documents that you might need to look at depending on the nature of your development. Site compound license, if your site compound is going to be located out with the development site. Oversailing agreement if you've got cranes requiring to oversail third-party land. Early access agreement, again, if you're looking at access into other parts of the site, perhaps before you've actually completed the purchase of it. So that's been a bit of just a rush through, but those additional points at the end there are more kind of, again, just points to note as part of looking at the overall project. So that completes my presentation. I see Fiona's back on the screen, so there we go.
Thank you very much, Charles. I'm conscious that we ran over slightly, so we unfortunately don't have time for questions. But if you do have questions for Charles, or alternatively, if you're looking to speak about other matters that weren't raised in this webinar, then please don't hesitate to contact me. But please don't contact me on development issues. I don't know much about that, and direct all of them to Charles. And our contact details are on the slides if you want to speak to us. So all that remains to say is thank you so much for taking the time to join us this morning. I hope you found it useful, and we hope to see you all soon.